You're listening to the Cash Podcast, creating affluence, success, and happiness with your financial surgeon, Adam Koch, President and Portfolio Manager at Libertas Wealth Management Group at libertaswealth.com.
All right, everyone. I'm here today with Geoff Kunkler, estate planning, real estate, and business attorney at Carlile Patchen Murphy. And today we're going to be teaching you about how not to make the kinds of money mistakes that Prince and Michael Jackson did. But before we get started, as always, a few housekeeping items. If this is your first time listening or watching, then thank you for joining us. The Cash Podcast is produced weekly, and as stated in the intro, Cash stands for creating affluence, success, and happiness. And that's our mission. My hope is for you to learn a little bit more on each and every episode so that you become more successful, wealthier, happier, and more educated than you were before you started listening today. So come back often and feel free to subscribe on iTunes and YouTube. In addition, you can also follow me on Twitter at Adam Koch and on Instagram at Financial Surgeon. Last but not least, all links, visuals, charts, and other educational resources are on our website. So that's it with the formalities. Let's go ahead and get started. So Geoff, thank you so much for joining me today. I really appreciate it.
Yeah, excited to be here. I know the podcast has a lot of great info, and hopefully we can share some tips for your listeners.
Yeah, no, I'm really excited about this one because I'm big proponent of people getting their financial house in order. And we're going to talk about it later. But the biggest thing that you do is one of the things I don't do, which is build estate plans. And it's probably, in my opinion, when it comes to people's financial lives, the number one thing that people procrastinate on, the number one thing we see people not doing enough of. So, but before we get into that, let me just kind of introduce you to our guests here. So for those of you that don't know Geoff, as mentioned before, he's an attorney that focuses on estate planning. So, trusts, wills, healthcare directive, powers of attorney. He also works with people to help them with real estate transactions, business startups, and honestly, a multitude of other areas in which you might need an attorney. I've used him several times for a number of different reasons. But he received his bachelor's and master's degree from Case Western Reserve, after which he attended law school at the Ohio State University Moritz College of Law. He's a chartered advisor in philanthropy, which just from the American College, which just makes him an expert in charitable planning for those of you who are interested. Geoff is active in several organizations, including the Columbus Bar Association, where he is the former chair of the Estate Planning Committee and is also a member of the Probate Committee. He's also a member of the Planning Committee for the Probate Law Institute of the CBA, a member of the Ohio State Bar Association, the Columbus Foundation Professional Advisors, the Delaware County Foundation Professional Advisors, the Catholic Foundation Professional Advisors, a founding board and member of the Central Ohio chapter, the National Aging in Place Council, what I think is really interesting. And he has published work in the Probate Law Journal of Ohio as well. So if that's not enough, Geoff was named a top lawyer by Columbus CEO Magazine in 2016, 2018, and 2019. And he was named Top Attorneys Rising Stars for 2020 by Columbus Monthly Magazine. He's rated AV Preeminent by Martindale-Hubbell, their highest peer rating for legal ability and ethical standards. And he's listed as one of Ohio Super Lawyer Magazine's Rising Stars for both last year, 2019, and this year, 2020. Most recently, I'm pretty excited, he was named to the 2020 class for Columbus Business First 40 Under 40 Award. So congratulations, a fraternity he and I both share. And Geoff has a big heart. One of the things I love about him, he volunteers his time in the special needs community as the current chair of the board of directors for Special Olympics Ohio, and was previously the inaugural chair of the development committee. He also supports the Ohio State University and is a member of the Buckeye Club. Additionally, he's a founding member and the current and inaugural treasurer of the Central Ohio Business and Wealth Planning Council. So I feel like I'm out of breath here.
Yeah, that was a very long bio. I didn't approve that.
I know you didn't approve it at all. But to close this, I got to close this well-deserved introduction out. Geoff was born in Worcester, Ohio, where his family still resides to this day. But he lives with Lauren and his daughter, Nora. And he loves eating out when restaurants are open and traveling with his wife and baby daughter. That is, whenever the state governors make it a possibility to do so. They've got two dogs, Teddy and Mowgli. So, Geoff, thank you again for sidestepping this crazy schedule of yours. And on a personal note, I mean, how have you been holding up with this whole stay at home? I mean, you're obviously sitting here in this beautiful background, which is not a virtual background, by the way.
No, it's not. It's not a photo. This is the actual bunker. We're getting by. So We've got 2 working parents and a 9-month-old who's napping for hopefully the length of this podcast, and 2 dogs that'll probably make an appearance
Sure.
vocally at some point during this as well. And that means that since Lauren gets the home office, I have to set up either in our kitchen, which isn't conducive to good volume, or in this case, I'm in my basement, which happens to double as my gym, my bourbon bunker, our laundry room, and everything else these days.
Looks
But we're
like
making the best of it.
with 2 dogs and a baby daughter, it looks more like a medicine cabinet to me.
Yeah, it can be at times. We've certainly tapped into this thing probably a little more regularly in the last 8 weeks than we would typically. So
Well, I know you've got quite the collection, so hopefully it doesn't get too dented.
hopefully I've got more than enough to outlive me, and I have to include it in my estate plan in some way.
Nice. Touche. What a great segue. So I understand that you recently had to figure out how to move your entire office at Carlile Patchen Murphy, all while social distancing. How in the world did that go?
Yeah, so that was quite a feat. So for those of you who don't know our law firm, we're a mid-sized law firm that does basically everything. So we're full service, meaning, as Adam mentioned, if you have a real estate question, family law, litigation, et cetera. So that means we've got about 35 lawyers and just as many staff people. And we sold the building that we had been on Broad Street since 1986. So we've had 4 locations all on East Broad Street, moving further and further east for the last 52 years. And then we sold that building and we moved over to Grandview Yard. And the timing is such that our lease was up at the start of May, and our lease started over in Grandview Yard at the start of May. So we had to move our people, our furniture, our technology, everything, all while socially distancing. So if you need to know how to, hire a professional company to disinfect an office, or how to make sure movers wear the appropriate masks, we've got all those answers. We had to have masks made for our employees. We have one-way streets in our new office. So
Wow.
we have got 2 doors. You can come in from the right or the left. Right now, you can only enter this way, and my office is back in the left corner, so I have to go the long way around to get to it. That way you don't
Jeez.
walk out and bump into people 6 feet apart. We're not open for clients yet. That'll start on June 1st. But
Okay.
it's been a crazy time, and we're probably one of the few businesses who didn't, have the ability to punt or move, back the timeline. But it was the hand we were dealt, and we pulled it off. And, on Friday, we were at downtown, and Monday, everyone showed up in Grandview, and it's been
Wow.
relatively seamless, as much as you could hope for.
That's great. I mean, I can't imagine how people move things if it's something heavy and you have to be 6 feet apart from one another, unless it's a 6-foot desk, that is.
Right. We've got, luckily, some of the desks literally are that long in the conference room, and a lot of the other stuff there's science to these packing crates, and we had to assign windows basically. So to make sure there weren't too many people packing stuff up all at the same time, and then unpacking, we rotated different times of the day and days of the week to load stuff up, and then movers using these sophisticated cart systems and numbering and lettering, get them and slide them into where they're supposed to go. You let them sit there and decontaminate, and then unpack your desk, and then they show back up a couple of days later. So
Wow.
it was interesting, and there were, of course, some unexpected hurdles. The day the moving truck showed up, they decided Grandview was going to pave our parking lot, so the entrance they had planned for these moving trucks to come in was under construction. So we don't know what happened with that timing, but again, we figured out what to do. And like any business or individual, if you're not resilient and able to pivot during this crisis, you're going to be left behind. And so we've shown that our staff is truly resilient and adaptable and ready to make changes.
Great. That's awesome. And sounds like the moving company and the movers are earning their money.
They absolutely. And what's interesting is, some of them deemed themselves essential and are open, and other vendors said, we can't open. So, for instance, most companies like yours, you have a nice sign in the lobby. You want people to know they've come to the right suite. We're our second floor of our building. We're not the whole thing. And so our original sign vendor said, I'm not an essential business, and shut his business down. We found another sign vendor who was able to make a sign for us. So just little stuff like that, where, some movers said, we can't safely operate. We're going to close our business. So, we had to find new vendors for a lot of stuff. And it's been an interesting time. And now with more businesses opening, hopefully it'll be easier for folks. But it's certainly, as we still have to maintain safety measures, even,
Sure.
God knows how long.
Good segue. I mean, my next question I was going to ask you, I mean, how has coronavirus changed how you plan on meeting with clients? I don't think this is going away anytime soon. So, I mean, how do you meet with the client and help and with their estate planning and things of that nature when you have to practice social distancing?
Yeah, great question. So for the last 8 weeks, it's looked like this. I've taken exclusively phone and video conferences with everything from prospective clients to current clients to, people who just have questions they want answered. And people have been very receptive to that. I've had people who one couple that I did the entire process this way. I've known the husband for a couple of years, but when this crisis hit, he still had to go to work and was worried about it. And so he reached out and said, I don't think I can see you, but I need to do this. How do we do it? And so we took our first meeting like this and talked about him and his wife and their daughter and what their plans are. I drafted the documents, emailed them over for them to review digitally. We had another Zoom meeting to talk about some changes, tweaking some ages and different things. And then finally, they even executed their documents digitally. We have an electronic notary at the firm who can help with most documents. And then for other documents, you still need 2 witnesses in Ohio. We have kind of antiquated laws. And so for their will, they were able to utilize neighbors and stay 6 feet away and sign, different sheets of paper. So there's ways to get it done.
That was going to be my question is, how do you pull off witnesses and notary? So it's an electronic notary? Is that how's that work?
Yep. So Ohio law, luckily, I think it was last year, but within the last year or two, we allowed for electronic notarization to occur. Our firm had not had anyone sign up or register for that because people were still coming into the office to get stuff notarized, or they'd go to their bank or wherever. And as soon as this hit, we knew that was going to be a big hurdle, that, if you want to sign a power of attorney or a living will, or even some trust documents, you need a notary. And so we quickly got registered for the software, had him take the requisite training. So my colleague, Andrew Marvin, is our designated person. And there's a particular piece of software, I believe it's called Doc Verify, that you have to get on with him so he can see you. You have to send him your driver's license to prove who you are.
Okay.
I think it's like a terrorist. You might have to hold the New York Times up to show what day it is. But he verifies who you are, and then he puts in your little digital signature, just like I'm sure you use DocSign or whatever that thing is for real estate documents all the time. So Ohio law allows that. What our law doesn't do yet is witnesses, since that's kind of the big problem. And unfortunately, Ohio's been super slow on this. So as soon as this hit, I heard states like New York and some places were changing their laws to allow for video witnessing. Ohio hasn't currently passed any or even proposed any legislation to solve that problem. So if you want to sign a new will, which is obviously a very important document, I think we'll talk about it a little later on in this podcast, but if you want to sign it, you still need 2 people to physically see you sign it. So people have gotten creative. I've had clients who had either friends or neighbors on the opposite side of a plate glass door or window who, I see you signing this, now I'm going to slide it under the door and you sign it. I had someone who didn't want to touch the same sheet of paper. So I mailed the will to my client, and I mailed the witness page to her neighbor. And they came out to the driveways. I'm so-and-so, I'm signing my will. Great. I know who you are. I can verify that. The couples next door signed theirs and mailed it back to me. They mailed the will back to me. We piece it all together, and it's an official legal document. But you still have to actually see someone. We can't do, unfortunately, a Zoom or GoToMeeting witnessing. But, I've had probably personally at least a dozen clients who pulled it off in this in various ways.
Weeks, huh?
Yeah, I can think of one couple where the wife works in the one of the medical centers at Ohio State, so she was able to utilize staff there, and the husband's a firefighter, so he was able to take his documents into the station. And so they didn't sign them together, which is a little weird. You usually sign your wills with your spouse, but they both, because they're working, were able to get it done. But it has been tough. I don't believe you can get a notarization done at a bank right now, which would be the typical avenue. Even if your neighbor or someone in your neighborhood is, you got to be worried about distancing and everything. So the e-notary has been nice, but witnesses is the hurdle, and hopefully we'll change that law. It's antiquated, doesn't make any sense to me. It's the only document I can think of really that you have to have a witness to prove who you are and that you were competent. So hopefully that goes away, or at least allows digital witnessing. I could say today, I could testify that you and I were here and I saw you sign something.
Okay. Yeah. Just for our listeners, does it matter who your witnesses are? Can it be anybody?
Generally, no. They need to be adults and they need to be competent. So you can't have a kid do it, and you shouldn't have anyone who's, been certified by the court to not have their mental faculties in place. And then the other big no-no is you don't want them to be in the document. So there's a strange law that says if my will says I want to give Adam my bourbon collection, which I'm sure he'd love to get his hands on.
Yeah, whenever you're ready to do that, just let me know.
If Adam is one of the witnesses to my will, he's disqualified from getting the bourbon collection. So the will isn't invalid, but any bequest he would have gotten, he's going to lose. So you can't have your beneficiaries be a witness. So that makes it tough. So that means you can't have your wife be a witness to it. You can't have generally your kids, but any other than that, it can be anyone. They don't have to be U.S. citizens. They don't have to have any certification or legal training. All they're saying, and they don't even need to know what's in the document. People get a little funny about, well, I don't want my neighbor knowing how much I've got or where I'm leaving it. So
Right.
how do I do this? And so it just needs to say, they need to be able to say that you were physically here today, not under any undue influence. No one was holding you at gunpoint, that you appeared to know what you were doing. So you had, capacity, you knew you were signing a will, and that I was physically present. I don't need to
Got
know
it.
who you picked to raise your kids or who you're leaving your money to, or whether, I'm getting your hot sauce collection.
Nice. I know you kind of mentioned or alluded to the potential law changes with regard to electronic signatures, but do you anticipate any other changes taking place as maybe the next year, 2 years, whatever, as we move toward a new normal in the estate planning world, or in your world, period, as an attorney?
Yeah, I don't know if it'll be COVID motivated or not, but some states are pushing towards electronic wills. So the entire document could be done on your, iPad or computer or whatever, and that would allow for the digital witnessing and everything as well. There's already been some pretty intense debate about that. So there's a group of lawyers called, and I may butcher this acronym, but it's the EPTPL, which is the Estate Planning, Trust, and Probate Law section of the
Okay.
Ohio State Bar Association. And they're the group of lawyers who meets, I believe it's quarterly, to talk about what bad cases have happened that we need to fix, what law should we have. They draft proposed legislation sometimes. And we try to make sure at the firm we always have at least one or two representatives on that. So one of my colleagues, Jane Mark, sits on that committee, and electronic wills have been hotly debated for a couple of years in that group. But I think they'll probably, with this pandemic going on, I would see that as possibly being a law change that we'll see.
What's your feeling about that? What are the pros and cons?
I don't see why we wouldn't do it. Why would we want to make it? Why wouldn't we want to make it easier for people to sign their wills? I think that the people who are opposed to it are largely, sort of antiquated people who are worried about, some sort of, fraud, or that we're losing the sanctity of the document. We're not in some legal office in a big stuffy chair,
Okay.
it's losing its effect in some way. But I can't see why we wouldn't do it. I mean, you can do almost everything electronically now, right? I mean, your clients
Right.
can log in and see their assets. Have they gone up or down, green or red, and so you can do your taxes online. If you e-file, you get your return faster, you get your stimulus check faster. So I don't know why we haven't come around on that yet. And I'd be certainly in favor of us making it easier for people. We're getting close. There was one kind of interesting court case. It's somewhere up where you grew up. I know it's in the Cleveland area. I want to say maybe it's like an Elyria case or
Oh, yeah.
something, but
Yep.
someone wrote a will up on a tablet.
Okay.
They had two witnesses there. They signed the tablet, and the witnesses also signed the tablet. And the court actually upheld that was a legal will and admitted the printed version of it. But they said because they were there together in person, they did physically sign, the stylus was good enough. And
Okay.
that was, like I said, that was a case last year in the Cleveland area. So even the courts seem like they're in favor of that. It's just laws change very slowly here in Ohio, and particularly in our area, we don't see changes very often.
It sounds like maybe it has a little bit to do with tradition too, and kind of letting go of the past.
So
Yeah.
I think so. I don't want to generalize too much, but there's
Sure.
a certain demographic that seems to be opposed to this. And I think a lot of them will probably be retiring with a big wave of fellow retirees.
Gotcha. Okay. That makes sense. So let's change gears and talk about the specifics and kind of what I really want to hear about, and what I want you to share with our listeners. So before I even ask the question, here's some statistics that don't surprise me, but I think are going to surprise everybody who watches and listens to this podcast. So in 2020, that's this year, obviously, this isn't some old 2017 or 2015 study. Caring.com did a survey, and they found that 78% of people have no estate planning documents at all. 78. So now that includes all age groups. So if you're a data, monkey like I am, I love data, I love numbers, I love picking them apart. So yeah, okay. So younger people probably don't have, maybe even the need sometimes to have a full-blown estate plan put together.
If they're under 18, they can't even have one.
Yeah. So let's just say, I don't know. So let's drill down in the statistics a little bit more. If you're between 35 and 54 years of age, which means you probably are, maybe you're married, maybe you're not, but let's just say you're probably married. A lot of these people are married. They have kids. In a lot of cases, only 27.2% of people between 35 and 54 years of age, 27%, have any sort of estate planning documents in place. And those over 55, which at that point, you got to have something. I mean, but less than half, only 47.9%, have an estate plan. And like I said, this doesn't surprise me at all because I see it literally every day in my office. And I don't want to say it drives me crazy, but it is a pet peeve of mine. When asked why these people don't have an estate plan, the answers are like this: that 50%, half, said that they just haven't gotten around to it. And that's the quote. I mean, it's one of those things where I think we started talking before we hit the record today and started the podcast, that you mentioned that, talking about mortality is no fun. I mean, it's obviously that's probably one of the biggest reasons, but 22% felt that they don't have enough assets to put an estate plan in place. And that's a myth. It's just a common myth, but it's a myth. And then 6% said they just don't know how to do it, or maybe who to hire. So you and I have talked about this several times before. And I mentioned earlier, famous people like Prince, Michael Jackson, Sonny Bono, they never had an estate plan. And didn't you tell me the other day, you say Prince, is his even settled yet?
I don't think it is. So, I mean, we're several years later and they'll probably be fighting about music rights for ages. So,
right. So, I mean,
it's the celebrity ones that you see on the news, but your stats are right. There are a huge number of people. I've seen a study that wasn't quite as grim as the one you cited, but the one I typically cite too was, I think it's from a Forbes article, and this one is a couple years old, but it's all of them always show that more than half of U.S. citizens don't have a will. And I think it was up to like 64% or something. And that was of adults who would be eligible to have one. And it's just crazy to me. It's not, as you know, it's not a terribly time consuming, expensive or difficult process. And so, those barriers that people may have aren't out there. And that's not even what they're saying. In their survey, they didn't say I didn't do it because it was too expensive, or I didn't do it because, it required some sort of advanced arithmetic or something. They said, I just haven't gotten around. So, I mean, it's, not much of an excuse. Talking about setting your family up for either success or disaster after you pass away, which I know you've seen, how wrong it can go on a personal level.
Yes.
Why not just do it? And the beauty of estate planning is, it's more or less do it and then forget about it. I'm going to want to try to reach out to you every few years and make sure you don't need to update it. But unless you have major life changes, like a death in the family or a divorce, or you get a diagnosis or something, your plan stays pretty static. We only make revisions a handful of times in your lifetime. So once you get it, you can put it on the shelf and, reread it every Thanksgiving with the family or something, or just forget about it till we reach out. It's not something that requires constant maintenance. It's very different than your investments. You need to talk with your clients, quarterly or even monthly, depending on, what kinds of things they've got going on. Your estate plan doesn't change that often. And so just get it out of the way. And, in terms of the point of, I think you said 6% of people didn't know who to find or where to get started, use the internet. Certainly I would prefer if you asked someone like your financial advisor or an accountant or even a neighbor or a friend. But I mean, get on Google and say, hey, estate planning lawyer, and type in your suburb. And there are a lot of different metrics out there that compile ratings where you can see, like Adam said, if you want to look up, I want an ethical lawyer. Well, if you look up that Martindale Hubble survey, you can see who's rated as maybe preeminent. These are people that other lawyers have certified are ethical. So if that's a concern for you, great. If you're worried about cost, if you're worried about cost, almost anyone you talk to will give you a quote before you sign up for anything. I can't imagine hiring someone without an estimate, and the legal field's no different. Everyone I meet with, I tell them, you're looking at approximately this, or maybe I'll guarantee it'll be this before we even get started. So I don't understand a lot of the delay in it, and I just haven't gotten around to it. Is such a sad answer.
Yeah, and I mean, I have a couple things I'd like to say, but my thoughts are piling up right now because I'm so passionate about this subject. But cost, let's just, before I forget to ask you, I mean, I'm not going to put you on the spot because obviously certain cases can start simple and become complicated, and other situations can look like they're going to be complicated on the surface and become very simple. But from the simplest sweetheart will with healthcare directives, POAs, to a more complicated full-blown trust with all the obviously associated documents, what is the difference, just so our listeners understand the difference between the costs?
Sure, absolutely. And law firms and lawyers will bill you in one of two ways. So the historic way that people billed is the hourly rate, where I keep track of every minute I talk with you and I jot it down. And in intervals at my law firm of tenths of an hour, I add up how much it costs. And then when we're done, you get a bill for exactly the amount of time I spend on it. For me personally, my rate's $320 an hour. So if I said, Adam, it's going to take me 3 hours to put this plan together, you're looking at, about $1,000 as a cost. People don't really like that unknown and really hate with emails in particular, that if Adam sends me an email and I send an email back, I can't enter less than 0.1 of an hour on my timesheet. So that means it's a $32 email at minimum.
Yeah.
People hate that notion, and they're scared to call that. So, if someone has a simple question, hey, I picked my brother for the guardian, but I'm really thinking maybe it should be my sister-in-law. They're worried about picking up the phone because it's going to cost $32 or $64 or something. And so that's generally not the way estate planning's billed anymore. But you should ask any lawyer you're talking to, do you bill hourly, or what most of us have switched to is a flat rate schedule? So, I'm getting into exactly this cost. I realize that if Geoff does this really efficiently, he'll probably make more money on me than he would have. And I also realize that if this takes longer, he's going to lose money on the deal. And we've basically tried to average out so that we come even on the majority of them at the end of the year. You win some, you lose some, of course. And so for a really simple package, we're pretty competitive. We're a mid-sized firm, so you could probably find someone who doesn't specialize the way that we do, or each one of our lawyers has a very specific area they focus on. So you could probably find a generalist who's a little less than us. You could also hire one of the giant firms in town and spend probably 2 to 5 times the amount. But, if it's a single person with, like you said, sweetheart will and healthcare directives, you're probably talking, $500 to $750, maybe $1,000 at the high end. For most couples who do a will package, which is the living will, healthcare POA, financial POA, and a will, you're typically looking about $1,000 as a couple to do a basic plan to get you started. Trusts, as you mentioned, can get a lot more complicated. A very simple trust that just says, if I pass now, my kids are too young to inherit this, so let's have someone manage it for them until they're out of college or adults or something like that. You're only talking for a couple, $1,500 to $2,000, somewhere in that range. The sky can kind of be the limit in this world. I certainly have some clients who have, taxable issues where I'm going to restructure their estate to save them hopefully millions of dollars on taxes. Well, of course, they're going to probably end up spending thousands or even tens of thousands of dollars with us to create that type of a plan. They're pretty few and far between. I don't know if we're going to get into taxes too much in this podcast, but a very small number of people actually pay those taxes. So I have a handful of clients who are in that complicated plan. I'd say even a pretty sophisticated plan typically wouldn't run you more than, $2,500, $3,000, somewhere in that range. And that would be pretty unusual. I do a handful of that type of planning a year. Most of my clients who are doing a comprehensive plan with a trust are, let's call it, around $2,000.
Okay. So first of all, that what I want to say, and just to piggyback here, is that's one time. I mean, it's not like you're paying it annually. And not only is it absolutely worth the money, it's worth the time. And I'm not talking about the time that you spend getting it set up. It's worth the time and the hassle and the chaos that can occur if you don't do it. So there's one story I'll share just briefly, and it's not even really a story, but it's somebody else's story about a friend of mine in Tennessee. He ended up going to the hospital, car accident, and he was non-responsive. First responders had no idea what medications he was taking, supplements, and so on. And when he got there, when they finally got his healthcare directive, his ex-wife was the person who made the decisions. So, I mean, obviously a huge problem, right? So, I mean, the good news is he got along with his ex-wife, but my point is obviously that's poor planning. The other story, obviously, which is mine, and I think you referred to this earlier, but very personal to me, is I lost my 13-month younger brother almost 3 years ago at this point. And, he was driving home one night, a very hot, humid evening, 87 degrees in Cleveland, and fell asleep on his motorcycle. And he was divorced, had full custody of his kids. One of them's autistic, 4 kids. I mean, and he had just was in between jobs. He was a mechanic, but he was in between jobs. So he had no life insurance. It had literally just lapsed 3 weeks prior. He had no will, POA, healthcare directive, nothing. So me being the financial planner of the family, of course, it was my job to kind of help put all these pieces back together. But let me tell you how horrible that was, and how much just a few appointments, and at worst a couple $1,000 if you want a full-blown trust, and to avoid probate and all that, how much that doing this and putting your financial house in order and having all these things in order can save. I don't even have words, I guess, to say hassle or chaos. I don't even know what word to use. So why is it, and I guess here's the question, why does it take something like a pandemic to motivate people to start getting their financial house in order and start doing these things?
Yeah. So estate planning, unfortunately, is something that people put off because they don't want to face their mortality. And so the pandemic makes everyone realize, wow, if I get this, there's 2 major things that could happen. One, I could be incapacitated. There's a huge number of people who get this and they're going to be on a ventilator, and it's not going to be for, an afternoon. It's going to be a couple of weeks. I mean, I just saw a story on the news yesterday that a Broadway star was in a coma for like over a month, and a young, healthy guy. And so, everyone's realizing if I'm incapacitated, I need to pick someone who can make my decisions for me. So I better have a POA for healthcare and for finances.
Like Terry
Or
Schiavo.
worst case scenario, what if you're, yeah, exactly. Worst case scenario, what if you're one of the people who dies from this thing, and you don't want to leave your family with a situation you walked into for your brother, that there's no guidance, you can't, there's not enough money because there's no life insurance. It's just a bad spot to be in. So I think something like the pandemic makes more people worried about their health. So certainly if you were diagnosed with terminal cancer and told you got a year to live, well, I better get my affairs in order. I'm going to go get my will updated. I'm going to, tie everything up. I'm going to, give clear instructions to my family, because you've been given this timeline, 12 months, you got to get it done before then. And so we have a lot of people who do come to us after some bad diagnosis where they know there's a finite period left, and the shot clock's now ticking, and I know what that clock looks like. For some huge number of people, they put it off to say, well, I'm not going to die tomorrow, so I don't need a will, right? Well, unfortunately, all the way up until the point where you can't make decisions, you don't have any negative outcome from not having an estate plan. But at that
Right.
last moment where you either can't make the decision because you're in a coma or you've passed away, well, now it's too late and we can't fix it. So what I always try to tell people is there's no harm in getting it done earlier.
No.
The only difference is you pay today versus whether you wait a year or 5 years, 10 years, but you're running this massive risk that you'll have that motorcycle accident, or you'll be in the car accident from your friend in Tennessee. And if the documents aren't already there, you can't do it once you're unconscious or you've passed away. And so you got to just knock it out. And it's a crisis like this is making some huge number of people worried about their health. And so those are the people who are now trying to get to us. We've seen a ton of people on the front lines who are very, very scared they're going to get this, who come to us.
Right.
We've also just seen people who, whether they're at risk, whether they've got, one of the underlying medical conditions or age-based, that have hurried up. I had a couple that we first started on their plan back in, I think, early 2018. I reach out to all my clients who are stuck somewhere in the middle at least once a month to give them a call and say, hey, just checking in. We still haven't signed
Right.
documents yet. We got to get this done. For 2.5 years, they've said, it's on our radar. We'll get back to you.
Right.
Once
Sounds
this
familiar.
thing hit, I get an urgent call. They're in Florida, of all places, and they're stuck there. They're not allowed to return to Ohio. They're self-quarantined, and they're an at-risk population. And so luckily we have the e-notary and stuff. We got them across the finish line, and they'll tell you the only reason they finished this thing is because this crisis was out there, and they're seniors, they're over 65, and so they're at risk. And they will probably would have kicked the can for several more years, even with me calling and harassing them. And I don't want to call people every day and tell them to get this stuff done. So for me, it's typically at least once a month I'm going to reach out. But, there's a ton of people who suddenly realized either I need to start this or I started and haven't finished, who we're trying to help out as fast as we can.
Well, I hope if anything good, and I hope a lot of good comes from the whole coronavirus pandemic. But one of the things in my financial planning world, being the kind of quarterback that throws the ball to professionals like you and other professionals, is I hope that this thing does motivate people to get this done, to get their healthcare directives, wills, powers of attorney. If you want to trust, if that makes sense, obviously that's more of an advisory role. You would help them determine that. But I really hope that this makes people do that and get it done. Because even if you get it done and then you end up having another kid, all it takes is a simple amendment. I don't mean to steal your fire here, but
you're exactly right. Well, and a lot of times we factor that in. So we have the conversation saying, are you done having kids, or is there a chance that there might be more? I mean, I can write the documents that say this will go equally to as many children as I have. And then if you have one and don't update it, the plan still works. I have other people say it's medically certain that I can't have any more. So let's go ahead and just name them. I'm leaving it to, Adam.
Okay.
Because there's just Adam in this case. So yeah, or
I didn't even know that.
if you want to make some updates, an amending in a document is very easy. With word processing and software we have to produce these things, if you want to switch or add in a kid or change, I've got my son as my healthcare directive. Well, he just moved across the country, so I need it to be my daughter. That's a 5-minute project for me to update, shoot you an email to sign. You can now sign it digitally and you're updated. So, we can get that done, literally in the course of, a half an hour of total time on both of our parts.
And one of the other things I see a lot is people who actually were responsible enough, say, after they had kids, to put together an estate plan is, they're 55 years of age or so, and the kids are in college or working full time, and there's still guardianship provisions on their estate planning documents. That's also a simple fix, right?
Yep, absolutely. That stuff's very easy to update, whether you go back to the person who did it the first time or even with a new lawyer. It's not, we see all the time people who did a plan when, like you said, they were young and married and had their first kid. And then it's not until close to retirement they look back at their plan, and they may not know if that lawyer's, still alive or retired to Florida or something. So I can easily update an existing plan for someone.
Just heard that yesterday,
not,
actually.
Yeah, we see it all the time.
Not sure if he's alive or not.
So,
anyway.
But no, it's easy to update a plan. And unfortunately, there's a huge population of people who, if you say, well, how did 20 years come to pass and you never updated this, who will say, well, no one ever reached out to me. And so we try to get in front of that. At our firm, we have what we call a diary letter. So on the 3, unless you want to be contacted more often, which some people do, no less than every 3 years, we're going to reach out to you and we're going to send you a letter saying, if these events have occurred, we should sit down. Do you want to come in and talk about your estate plan? So we want to stay on your radar for a few years. And I have some people who ask for it to be 2 years or 1 year even. We're happy to accommodate whatever clients want. We want to actually reach out to you. When people say, well, this is crazy to me that, 20 years passed since my last lawyer did this and he didn't call me once, and you guys are going to stay on top of us. And it's for that reason, Adam. We don't want people to have their plans out of whack, that
right.
The plan was set up to care for little kids who are now adults with their own kids. And so the plan isn't going to the right people. The right people aren't making the decisions. So yeah, certainly every 3 to 5 years, I would relook at who you've picked for each job, who you've named to inherit, at what time they inherit. And, even as your assets change, your plan might change. I mean, I have folks who I just updated their plan that they hadn't done one in ages, and, they didn't have a lake house before. So now we have provisions for
Sure.
How do they want to keep this lake house together between they're sort of a Brady bunch. There's him and her, and they each have 2. Well, how do we get these 4 kids who aren't all of the same parents to co-own a lake house? We better put some provisions in their trust to figure out how we sort it out. What if someone wants out? How much do they get paid? Who's in charge of management? If that wasn't laid out, there's almost no likelihood that plan would work out successfully. Oh, yeah. And that only needed updating because they bought a lake house.
And that turns into a mess later if it's not prepared for. I know that I've seen that personally in my conference room. Another thing that I see, I don't want to say I see a lot of this, but when I see it, it's a huge mistake. It's people who have trusts and they go through the time and they spend the money and they build a beautiful trust and then they don't fund it. Can you explain what that means?
Yeah. So the process of funding a trust is either putting the assets into it or pointing them towards it. And I'll explain what I mean by both of those. So to put something in a trust is a retitling process. So people think they go to their lawyer, they create the trust, and they're done. That's really the start of the homework for the client. They then need to actually get their stuff in the trust. And to get something in a trust, you go to the custodian of the asset. So take a few examples. If you want to put a car in a trust, you go to the Bureau of Motor Vehicles and say, I want to move this from my name, Geoff, to the Kunkler Family Trust, which is what Lauren and I's trust is called. If I want to put my bank account in, I go to the bank. Now, some of this is tough during social distancing. The B&Bs aren't open right now. Banks aren't open to come in. You may be able to do this online, but typically you would walk into your bank. So I bank at Chase. I would bring my trust to Chase and say, here, banker, move my personal checking and savings account from my name into my trust. Mm-hmm. For a account with Libertas, it's easy. You call Adam and him and his team will update it for you. If you don't work with an advisor, then you have to do a lot more of this on your own. The 2 options are either put it in today, which is easy. Some people don't like the notion that like their check would say the Kunkler Family Trust. They think that has a certain connotation. I don't know how many people are writing checks nowadays. I couldn't tell you where my checkbook is, but right. If you're worried about that, the other option is to make it the beneficiary. So almost every asset you think of, you can put a beneficiary on. So the same way that you could have put your car in your trust, you can also go to the B&B and add a transfer on death that says the moment Geoff drops dead, his car becomes property of his trust. You can do the same thing at the bank. It's called payable on death. For all of your accounts with your financial advisor, you can add a POD beneficiary to a brokerage account, an IRA, a 401k, life insurance, etc. But if you haven't directed the stuff to the trust might say split it equally to my 4 kids, but they're too little. So let's hold it until they're 30 and let their Uncle Joe manage it. Well, if you don't actually do that updating process and retitling and you name your kids as beneficiary on the IRA and the life insurance, they're going to get it. So they're 18 years old and they're going to walk into your retirement account and college is going to look a little different for your kids than you probably thought it was going to. And so it is a huge problem. We see people who don't do it all the time. And the problem is that the actual hard part for the client, more often than not, isn't making the decision. They know who should raise the kids and they know what age they should get it. But the hard part is they don't want to go to each bank and go to each financial institution. So, we give them clear instructions on how to do it. We try to follow up with them. And, for a lot of times we'll do the real estate for them. We have some clients who have us do all of the funding. We have one paralegal who she's great at it and can do that. You're going to pay, her hourly rate. So if it takes her 5 hours to put it together, you might spend $1,000. But again, to Adam's point earlier, even that level of cost is going to save you so much in headache and work on your own time on the back end that, I have, it's not very often, but probably a handful of times every year, someone either because of age or how busy they are or whatever else just has us do all that for them. And we like I said, we've got one person who really likes to do that kind of work. And so she does most of it for us and she's great at it. Most people can do it on their own. It's not that difficult, but you got to actually put your stuff in.
Right. All right. Last question before I let you go here. So I get this often from clients, especially people who are younger, and they'll say, I'm not married. I don't have a lot of assets. What should I have in place at a bare minimum, period? And then to parlay on top of that, what should I have in place, even if I'm not married and don't have kids, but I'm working on the front lines in the healthcare facilities right now?
Yeah, absolutely. So the kind of core essential estate plan would include a healthcare power of attorney for sure. That's the document that says who talks to your doctor if you can't. It might include a living will. That's what your wishes are with regard to life support. So if you ended up in a coma as a result of this crisis, do you want to empower your spouse, or you, in this case, the person's not married, so a friend or mom or dad or someone to make the decision, or do you want the doctors to say, if it's certain, pull the plug? You should have a financial power of attorney that says if you get sick from this, who can call Adam, who could file your tax return when it's due, who could pay your mortgage or rent or whatever you've got. You absolutely need those. Those are what I call disability documents. And then every adult should really have a last will and testament as well. It's not going to have guardianship provisions or anything, but says who gets your stuff. If you don't do a will and you're single and you don't have kids, Ohio law actually figures out where your property should go, and it can have some odd outcomes. So if you're single, no kids, they would say if you die, they think you want to leave your stuff to your parents. Well, a lot of people say, well, my parents don't need this. I'd rather it went to my nieces and nephews or my church or, a dog rescue that I'm passionate about. Well, they're always going to go to your closest relatives. They're going to try to find your parents. If they're not around, brothers and sisters. If they're not around, nieces and nephews. Then we go back up to grandma and grandpa, and the family tree keeps getting bigger. We have something called a table of consanguinity where we try to find your closest relatives. So I had one of these a couple of years ago where a nice young man, as far as I could tell, who lived in the Pacific Northwest had no idea that he had a great-great aunt here in the Columbus area. Well, she passed, no relatives to be found. So we hired a genealogy firm who said, based off the family tree, this guy who's never heard of this lady is the beneficiary. And he walked into several $100,000 by being the closest relative, and she'd never met him. Surely she would have wanted a good friend or her church or someone to get that money. And then worst case scenario, if we can't find a relative, the state of Ohio gets it. And that's definitely not what you want. So people think I'm single, no kids, no family, I'm not worried about it. It's probably more important for them to do a will. Now, they don't need a trust that holds it for any period of time or anything, but New York got a multi-million-dollar estate a couple of years ago. Some art collector with no family. They hired a genealogy firm. They tried to find him, didn't find any relatives. State of New York got everything. And it's like, this should be in an art museum someplace or donated to something this guy's passionate about. But
that's
unfortunately, he didn't do it. So your key plan then is those 4 documents: the last will and testament, healthcare POA, financial POA, and then probably a living will. Most clients do that. If you don't do the living will, we can put that in the healthcare POA. So it's just something to talk about. And a lot of that is, pretty simple to put in place. It might be 1 or 2 meetings as opposed to a 3 or 4 meeting process.
Right. Not time consuming at all, for sure.
Nope.
Okay. The last thing I'll leave everybody with here is we literally, I'm talking in the last month, started implementing something that I've been thinking about doing for 3 years, again, since my brother passed. We call it a safe haven kit. The whole initiative is called My Promise. The concept is, I want to make the promise to my clients and the people we know, our friends, our family, to make sure that they never go through what I had to go through in that situation with my brother. And this is everything that Geoff's talking about, all these documents, but it also includes making sure we have medications, supplements for first responders on a USB ice key, which will go on your keychain. We just got a huge box of these things, as well as fireproof safes to put your documents in. I know we're talking about a lot of electronic things today, but I still think there's a lot of people that keep paper documents. So this would think not only your estate planning documents, trusts, wills, POAs, but password lists. Kim here at our office is helping to kind of hold clients' hands through this process of getting their passwords down. So if something were to happen to you, your surviving spouse or whoever, your family members that take care of you, they know where to pay your bills. They know what you're paying, what the websites are, how to access it, where the spreadsheets, passwords to computers, things that you just don't think too much about that are kind of beyond that realm of just a basic estate plan, but I think are also very important. So thank you so much,
stuff, Adam.
Sorry, go ahead.
That's a great stuff. I mean, you're exactly right. That stuff's really important. And just on the estate planning piece, until we get electronic wills, you actually need the original paper will to give to the court someday. So you need to keep it in something like that box that you're giving out to all your folks.
Something that's inked, right? I mean, it can't
Right.
be a copy. Yeah. Well, thank you so much again for being here and for offering so much valuable information. I think we kind of went off the rails. It's my fault. And I started asking too many questions, but I really appreciate all the valuable information and education. And I'm sure our listeners do as well. So, all right, everyone, that's it for today. We realize there's thousands of podcasts out there, and you chose to listen to ours. So thank you so much for listening. Be sure to subscribe on iTunes and YouTube. Please feel free to share this podcast with your friends. And if you want more educational information, you can sign up on our website at libertaswealth.com to receive our screencasts, videos, articles that we send out on a regular basis. Again, you can also follow me on Twitter at Adam Koch and on Instagram at Financial Surgeon. So thank you so much again for joining us, and we'll see you next time.
Thank you for listening to the Cash Podcast with your financial surgeon, Adam Koch. To see any charts or images that were mentioned in this show, or to check out additional articles, videos, and other educational resources, head over to libertaswealth.com.